Okay, welcome to CBIA's HR Hotline Live. I'm Diane Mokriski, Employment Counsel at CBIA. So today we're going to be talking about hiring practices and the potential legal trouble that employers can find themselves in when they unwittingly either violate the law or take some action, make some sort of decision that can expose them to liability. I know we had some people submit questions in advance, and one of those questions was something to the effect of like, what's the worst thing that can happen if we break this law? So we'll talk about that. We'll talk about the damages that applicants and employees can recover, whether those are just penalties from the state or whether they're actual money damages. So we can discuss, this is a hotline webinar, so that means we're relying on the questions that you all submit. We're just going to have one slide today, and it's going to just be a list of issues for you all to be aware of for hiring practices. So we can discuss things like offer letters, interview questions, background checks, when you can or cannot, if there's such a thing, revoke an offer. So we can talk about all things like that. We will touch on the questions that people submitted in advance, but we'll also take your questions live. That's the point of the webinar. So please submit your questions through the Q&A, and we're going to leave the chat function for just that, for just chats amongst the participants and information that CBIA wants to disclose during the course of the webinar. Once we're finished, CBIA will send out a copy of the audio recording, the video itself, as well as a copy of the slide to everybody that registered. So as usual, I'm joined today by two partners from Carmody Torrance Sandak Hennessey, Nick Zaino and Vincent Farisello. Both of these gentlemen have extensive expertise in all things employment law, so we're very lucky to have them today. Hi, Vincent. Hi, Nick.
Hi, Diane.
And
Hi, everyone.
You'll see that Nick is pretending to be Vincent today, but that's not true. Only Vincent, raise your hand.
I'm the real Vincent Farisello, so I will stand up.
Yeah. I can only be so lucky.
Okay, so let's start with one of the things that is most clear cut in this area, and that has to do with offer letters. This is something governed by Connecticut statute, what exactly has to be in an offer letter, but we can also talk about what should be in an offer letter in addition to what the statute requires. So which one of you would like to take that on? Do you need an offer letter and what should be in it?
So I'll jump in quickly, and Nick, feel free to supplement my comments. But Connecticut law does require that employers advise employees in writing of the basic terms and conditions of their employment. And I think the best, easiest way to accomplish that is through the use of an offer letter. And so, things that I think should be included in an offer letter. Well, I'll start with things that should absolutely be in an offer letter: what the position that the individual is being hired for, what their rate of pay will be, what benefits they'll be eligible for. Recently, you also now need to include the pay range, the pay range for that position, and I'm sure we can discuss that in more detail as we go through the hour. Other things that you should include in there. I think it's really important to have that at-will employment disclaimer in there. At all points, you should always be trying to reiterate and reinforce the idea that employment is on an at-will basis. You should include a disclaimer that the offer letter is not in and of itself a contract. It doesn't create a contractual relationship between the parties. There should be an opportunity for the employee or the applicant to sign, indicating their acknowledgement and acceptance of the terms of the offer letter. Great idea to include what contingencies there might be to move forward in the process. For example, let the individual know that they'll have to prove their authorization to work in the United States. And as applicable, you might give them notice of the contingencies for drug testing, if that's going to be something that happens, if there's going to be a background check, if that's a contingency for hiring. and also whether there might be the requirement to execute any restrictive covenants, something like things like confidentiality, non-disclosure, non-solicitation, non-competition, again, as applicable. One thing I failed to mention of things that should absolutely be included in there is also what the anticipated schedule that the person can anticipate. I always think it's a good idea, not just to say, here's what the schedule that we anticipate is, but also a disclaimer that, hey, that schedule can change based on business needs. I don't know, Nick, if there was more you wanted to add about.
Yeah, no, I think you hit the main points. And I just think it's important that employers use offer letters. I think it's your opportunity to set the terms, most importantly, the employment at will language. And so, I think I can't think of why an employer would not use an offer letter. I think it's important to have that in writing right out of the gate, what the basic terms are. And I think you covered the key points, Vincent.
And one thing I'll just point out is I recently was going through a Department of Labor audit on a wage and hour issue with a client, and it was interesting. One of the things that the DOL requested as part of that audit were copies of the offer letters. It's funny that they kind of assumed that the employer was using offer letters, and they actually requested the offer letters for each of the employees that were part of the audit. So back to your point, Nick, I just think it's a great idea and foolish not to use offer letters.
So you're saying it's a good idea to use offer letters, but not required. So if an employer does not use an offer letter, there is something that needs to be provided in writing, though. Am I right? The list of 3 things, right?
Yeah, the basic terms and conditions of employment, things like the pay, the position, schedule.
Yeah. Okay. So you might as well just put that in off, because you also want to tell people it's at will and everything that you just said. So it is a good idea to have an offer letter. And Karen just hold on one second. I thought Karen Weatherall asked a question. Was that in the chat, Karen? Hold on. She did. Okay. Does an offer letter need to include the pay range, not just the rate of pay? So does it have to include the whole? So you want to talk about salary disclosures and what those rules are?
Sure. So that's a relatively recent statute from a few years ago. Basically requires employers to provide wage ranges to both applicants and also to current employees in certain situations. So with regard to applicants, the obligation is to provide the wage range to an applicant at the earlier of the applicant's request at any time during that application process. If they request it, you have to provide it, or prior to or at the time that the offer of compensation is made. That's the language that's in the statute. I think conventional wisdom is that means at the time you make the offer of employment to the individual. So again, if you're using an offer, I mean, you have to disclose that wage range to the applicant no later than at the time the offer is made. So what better time to do it than in an offer letter?
Okay. Now I know we said we're only going to take questions through the Q&A, but they're sitting here right in front of me, so I can't not ask you these. So could offer letters be signed on the first date of employment? I'm not, as opposed to what? Yeah. I'm not exactly sure, but.
Yeah, I mean, I think they can be, but it would be better to do that prior to the first day of employment, so that when the employee, and the reason I say that is when the employee resigns another job, right? You want to make it clear that when they accepted your offer, they knew that they were accepting an offer of at-will employment. And they knew that when they gave notice, presumably to their prior employer, so that if you ever are in a position where you need to revoke it, right, you say, look, we extended you an offer while you were still working at your prior employer. You knew this offer to come work for us was at will. You sign the offer letter, and typically the start date is after the date, you provide the offer letter. So it is much better to provide the offer letter before the start date.
Okay. So there's a question about whether they be signed, and I'm not sure if they mean the employer or the employee, but what's the answer to both those questions? Who should sign an offer letter?
I
would
think
say
it's
both sign.
yeah.
Yeah.
I think it's preferable. I don't think it's absolutely necessary, but I think it's absolutely preferable.
Okay. All right, so I'm going to address some of the questions that came in advance. And this is going to be, we can probably talk a fair amount about background checks, because this will also touch on the offer letter and what it means to revoke an offer letter and what are there legal implications there. So the question that came in was, how do you consider or reject a candidate based on their criminal history? So for example, if you know you're hiring someone that's going to be going into people's homes and you do a background check and you find that there's a criminal history of something that you wouldn't like, violence or larceny or whatever, how do you make those decisions, and how do you revoke the offer?
Yeah, so I'm presuming that this employer who's asking the question is using a third party to conduct a background check as a condition of employment. So an offer is extended, conditioned on this background check. The third party that does it provides you, the employer, the results of the background check. You look at the background check report, you notice that the employee has been convicted of larceny. This is a job that requires a high degree of trust. This is a fairly recent conviction, say it's for a felony or whatever. You decide that you want to, based on that report, not go forward with employment, not continue the person's employment. And so there is a process that you would need to follow under what's called the Fair Credit Reporting Act, because you relied on that third party, that vendor's report in making that decision. You have to give that employee what's called a pre-adverse notification letter, letting them know that you received this report, providing a copy of the report, providing the employee an opportunity to rebut the report. Maybe the report is inaccurate, maybe they had the name wrong. And you give the employee an opportunity to rebut it, and then you have to issue what's called an adverse action letter. So there's a very formal process for how you do that under the Fair Credit Reporting Act if you're using a third party to conduct that criminal background check, and it comes back that there is an adverse finding that doesn't, where you decide not to move forward.
And what if you do the background check yourself?
Yeah, if you do it yourself, you don't need to follow that formal process under the Fair Credit Reporting Act because you're not using what's called a consumer reporting agency. However, we always like being upfront and honest with employees about why you terminate their employment. And I would probably say the same thing on why you're not hiring somebody for their job. So if you've got good grounds and you feel comfortable that, look, this is a conviction that we believe is related to your employment, we're not comfortable moving forward, I would advise the applicant that you're not going to move forward for that reason. So kind of similar, but not exactly, not as maybe not legally required under the Fair Credit Reporting Act, but probably the better practice.
So if you issue an offer letter and it's in writing, let's say you didn't use a third party and you want to revoke the offer because you found something that you didn't like, is there any risk in doing that? Because you gave them an offer, let's say they even accepted the offer, and then before they start, you discover something you don't like. Are there rules about revoking that offer?
So that's why, remember the point Nick made early on, why it's so important why it's so important to make clear that the offer is on an at-will basis. It's for at-will employment. There was a court case that came out in Connecticut, I don't know, about 15 years ago or so, that actually reinforced the idea that concept of at-will employment, if articulated, if communicated that way, even extends to that pre-employment process. And that case dealt exactly with that type of issue where an employer had made an offer of at-will employment to a candidate. That candidate, in reliance on that, went and left their prior job. And before they started at new employer revoked the offer. And the court held that since the offer from the get-go was on an at-will basis, that there was no obligation for the employer to move forward, assuming that there was no illegal reason for them revoking the offer. And there's lots of reasons that can be deemed illegal or unlawful, but just from a contract basis or even an equitable basis, it's okay to do.
Yeah, and I'm always very cautious about, or would advise employers to be very careful about revoking an offer that you've extended, that the person accepted, that the person resigned from their employment, to come work for you. Maybe they moved from a different city they relocated, and they're relying on this employment to kind of go forward. It is absolutely critical that you be able to show that they signed that offer letter that says it's at will. But it's just as critical for you to have a good solid basis to revoke that offer, notwithstanding, some case law that would support that. I think there's equitable claims. Like you want to have good solid basis to revoke that offer and not just do that sort of on thin grounds. So.
Okay. So we've had some questions were submitted in advance that had to do with, as I mentioned at the start, like what's the worst thing that can happen if we ask an illegal question. Let's start with what are the illegal questions. So let's say we're talking about interviewing, and let's do the application as well. What are the things that you definitely don't want to ask?
So definitely you can't ask during the application stage on the application, unless you're otherwise required by law, you cannot ask about criminal history. Connecticut has had a ban the box statute on the books for some time. So you don't want to ask about criminal history on the initial application. You also don't want to, you can't ask about an applicant's wage and salary history in the employment application. In terms of, what are the consequences of that? Connecticut recently, passed something called the Clean Slate Law, which expanded the types of criminal history, expanded the types of erased criminal history that can't be used in the decision-making process. And so you can't ask about those types of erased criminal history even after the application process. Anything that's not an erased criminal history, you can certainly ask about after the application process. But violation of the Clean Slate Law is treated as a discriminatory practice under our human rights law. So violating that could subject the employer to something like a CHRO or EEOC type claim. With regard to violating the requirement not to ask about salary, wage history on an employment application. That statute provides for the potential for a private cause of action and has a 2-year statute of limitations. And so an individual aggrieved there can file suit in court against the employer.
All right. So if you've got an applicant who can prove that they were not hired because of their race, do you agree it's not a matter of a state agency assessing a fine? It's what we're talking about is someone filing a discrimination complaint and potentially being awarded damages for, like, what would they have earned if they had been hired because you didn't hire them for a discriminatory reason? So we're talking, do you think like lost wages and attorney's fees and things like that?
Yeah, all those damages that would be recoverable under Title VII under the Connecticut Fair Employment Practices Act. And so you shouldn't be asking, also illegal is to ask any question at the pre-offer stage that might require an employee to disclose a disability. So any question about have you ever filed a workers' comp claim, certainly any question about do you have any medical conditions, are you medically able to do this work? Any question that the answer to which you can't make an employment decision should not be asked, right? So if you don't have a basis to make an employment decision on that question, you shouldn't ask the question. So you shouldn't ask somebody their gender, their age, their national origin, all those things that are really obvious. And if you do, like the risk if you do is exactly what you said, Diane, that the applicant says, geez, they asked me If I was pregnant, they asked me my gender, they asked me my age, and then you don't hire that person, that question is going to be used against you or could be used against you in a discrimination claim saying the employer was curious about my age and then I didn't get hired. And so, yeah, the risk is you get a discrimination complaint subject to all the damages that are available in any other discrimination claim.
Okay. Let's go to the first question that was submitted this afternoon. Can you include language in an offer letter that lets the applicant know that they're going to be required to participate in recorded meetings?
That's a bit of an unusual question. I guess the answer is yes. If you have, I guess, certain types of meetings that for, legitimate, valid business purposes, you record. And it's a good idea to give the employee sort of advance notice of that, you have a particular need to record certain, I would assume certain types of meetings, not all meetings, but certain meetings that for whatever reason you record. Yeah, I think it would be a good idea to make sure the employee understood that and make sure you have a good basis for recording those meetings. It's a bit unusual from my experience, but maybe there's valid reasons for doing that.
Okay. Vincent, back to that salary range issue. This question is, if they initially provide a verbal offer before they follow up with the written offer, are they required to provide the pay range at the time of the verbal offer, like as soon as the offer is made verbally, or can you wait until you're making it official in writing?
Well, I think my recollection is the statute just says at the time an offer of compensation is made. So if it's made verbally, then that's the time that you have to do it. The point of putting it in writing is so that you can prove that you complied with the statute. So great that you did it verbally. I think even better if you follow up with it in writing.
Okay. So this question from Sarah, the question is, are Connecticut employers required to give an offer letter to employees who are switching to a new position in the same company? So I'll throw that to you to answer, but I just want to emphasize it's not that you're required to give an offer letter per se, right? When you first hire someone, you provide them in writing 3 pieces of information that Vincent mentioned. Do you think the rule is the same when you're switching positions within the company?
Yeah, I don't think you need, I think you need to let the applicant, the employee know what their new pay rate is going to be. If it's a different pay rate or the same pay rate, and, if their title has changed, if their work schedule has changed. So yes, I would follow the same process, although I don't think you need a full blown offer letter, that you have when you first hire somebody. So you don't need to, I think, reiterate all those things that are already part of the employment relationship. You're certainly not going to talk about contingencies and, but I do think you should, you should include something. And I've seen employers use forms, like they're just internal forms that some employers use to document that they've been transferred or that they're promoted to a new position or going into a new position. Here's your new pay rate, here's your new title, here's who you report to, here's your work schedule. It's full-time, non-full-time. So yeah, I think that should be in writing.
And
Okay.
to piggyback on that, when someone does have a change in position, that is one of those other situations in which that wage range disclosure law is triggered again. So you do have to, upon a job change, you do have to inform the employee again what the wage range is for that position.
Okay, and so that was the next question that you mentioned, disclosing pay ranges to current employees. And so are there any other circumstances where there would be some duty to disclose pay ranges to the people that already work for you?
Yeah, if they request it. But I would also say that the statute says for current employees, you provided either upon request, you provided upon request, and also whenever there's, like I said before, a change in the position, whether it's lateral, promotion, demotion, or whatever. Caveat to all of that, of course, is the employees or the applicant, frankly, they're only entitled to get the wage range for the position that's at issue. For if it's a current employee for their own position that they have, the wage range for their own position, or the pay range for the position that they're about to take. In the case of an applicant, for the position that they are seeking or that they have applied for, there's no obligation to provide any employees the pay ranges for other positions.
Okay, and so we've got a couple of questions about ads. So you're not, at this point, you're not required to put the range in the ad, right? But if you do disclose the range, the salary range in the job posting, is that enough?
See, I would caution against relying on that just because, just on the off chance that someone has heard about the open position from some other source, maybe from a friend.
Yeah, they're not responding to the ad, right?
Exactly,
Yeah.
exactly. And so if you've never provided it to them, you might wind up not complying with the statute. So it's fine. There's nothing that says you can't include it in the posting. For some folks, that might be a good idea. And a lot of times that will go a long way to satisfy the statute, but I don't know that it will in all cases.
Okay. And you guys have mentioned how important it is to mention at-will employment in the offer letter. Can you give us just a quick summary of what does that term actually mean?
So it basically just means that either the employee or the employer is free to terminate the employment relationship at any time, with or without notice and with or without cause. It's basically saying that there's no obligation for us to employ you for any period of time, nor is there any obligation for you to remain employed for a certain period of time. It is one of the most fundamental and I think important things for employers to preserve, except in cases where they do want to try to lock in, they do want to, or they, it does make where they are choosing to commit to employ someone for a period of time. But that's usually for much, higher level executive type positions or some professional positions. You're not going to really see that, when you're talking about your typical rank and file employees. I think at will is probably one of the most important fundamental things to preserve.
All right, so we've got a couple questions about drug testing and people testing positive for THC, or it can really be any drug. If you've got a disclaimer that says we're going to be testing for THC and it's got to come back negative in order for you to get this job, and then they test positive, is there anything that needs to be, the first question has to do with government contractors, which I suppose there may be something in that contract with the federal government that will say exactly what they have to do, but is there anything that you know of that needs to be done officially if someone fails the drug test and so they won't be hired?
Well, for marijuana, remember, qualifying patients are protected under the Connecticut Palliative Use of Marijuana Act. So if a job applicant is test positive and they present to you a marijuana card, showing that they're a qualifying patient, they've been approved to use marijuana for medical purposes, then you couldn't use that to deny them employment. But beyond that, it's important, if you are going to deny employment to individuals who test positive for THC, that you have that clearly in a policy, in writing, and you make that clear, again, in your offer letter, that you have a drug testing policy and they're subject to drug testing requirements. And so our statute allows for that, but you have to be clear in your policy that you prohibit that as a condition of employment.
If a person has a medical marijuana card from the state of Connecticut, does that rule still apply if the employer is a federal contractor?
The fact that they're a federal contractor alone is not enough, and there's a case on point to trump the Connecticut statute. It has to be that you are required under federal law, like CDL drivers, to deny employment to somebody who tests positive. Not that you're simply a federal contractor, because there are a lot of federal contractors, and it doesn't automatically mean that you must deny employment to somebody who tests positive for marijuana use.
Where that comes from is a lot of contractors. So again, remember, kind of take a step back. Can't discriminate against someone for being a qualifying patient. The exceptions are which means you can't, refuse to hire someone simply because they're a qualifying patient. The exceptions are unless you're required to not hire them by federal law, or you're required to not hire them in order to receive federal funding, like as part of a grant. Usually, grant would say that within the grant. Some of the confusion comes from the fact that many contractors are subject to the Drug-Free Workplace Act. But that really just means that you're agreeing to certain prohibitions about having drugs in the workplace, not necessarily about what someone does outside of work. So that's why I think there's some confusion out there when it comes to federal contractors. But the real exceptions, like I said, are unless required by federal law. The easiest example, Nick, you just used it, is Federal Motor Carrier Act kind of regulations, or if you're a federal grant recipient, and that's specifically within the grant. And those you don't see too frequently.
Okay. So talking about, Vincent, you mentioned the Clean Slate Act, and you mentioned, I think you were talking a bit about erased records. So we've got a question about recent convictions. So what is generally considered recent, i.e., is it the last 7 years or what?
So for purposes of the Clean Slate law, that provides for, like I said before, automatic erasing of certain criminal records. And so that includes the statute references misdemeanors that are more than 7 years old, and certain Class D or Class E felonies. Those are like among the lowest level felonies. Certain unclassified felonies that are more than 5 years old. But so those are kind of the time periods we're talking about. If you're talking about a felony or a misdemeanor that's within the last 2 years, 1 year, 3 years, that's generally going to be fair game. And again, I'm talking about convictions here.
Okay. So what if you do a background check on an applicant and you don't use a third party and you see that they've been arrested, but the court system works slowly and you need this person to start as soon as possible? What do you do then? Can you revoke because it's at will and you don't want to deal with it? Or do you have to wait to see if they get convicted?
Yeah. Oh, go ahead, Nick. Sorry.
No, I was going to just say, I don't know that I would adopt necessarily a cookie cutter approach in every circumstance for that. Like I would want to know, is it a pending arrest? And it sounds like from your question, it would be a pending arrest. And then you'd want to know, is that pending arrest for an offense that if they become convicted for, you would deny their employment? So going back again to the situation where, the easier one, let's assume it's somebody who's been arrested for embezzlement. It's a pending charge. You're hiring them to be the controller in charge of, your money. And so in that situation, it might be prudent to say, look, we understand there's a pending arrest. Your position is to be employed as the controller. We're going to suspend that for a little while. Like, we're not going to have you start, pending the resolution of this. And maybe it just takes too long and you can't continue to hold that job open while the employee or the applicant is telling you that they're innocent and they're going to be proven innocent. At the same time, it's an offense which, if proven true, you wouldn't continue their employment as a controller. So in that case, you might suspend pending some reasonable time to get that situation squared away. If it's an arrest for something for which you wouldn't make an employment decision, you might go forward with the employment relationship, maybe ask the the applicant or employee to keep you posted on how that comes out. But you necessarily, in case it changes, different charges are brought. It can be upcharged. The charges could be charged down. So there may be reasons why you want to be kept abreast of what happens with that pending arrest. But you can continue the employment in that situation because it's not really relevant, to their employment. So it just sort of depends on the various circumstances as to which approach makes sense.
Okay. How about this one? Are we required to use an application, or can we just have people send in resumes?
I mean, I don't think you're required, but again, this is another thing that I think is a best practice. The employment application form is your opportunity to elicit the information from the applicant that you want to make an employment decision, subject to all the rules about, ban the box and certain information that you can't ask. But it's your opportunity to say, where did you work? Don't omit any periods of employment. Any information that you provide that is inaccurate, misleading, or false, we have the right to revoke your employment. We have the right to terminate your employment if we discover it later. Like, that form is another opportunity for you very early on to establish that employment would be at will. That form is an opportunity for you to ask the applicant in writing, why did you leave that employment, right? They're not going to volunteer that in a resume. In a resume, the applicant is telling you what they want you to know. And so the information comes across a little differently in a resume than it does in an employment application form. So yes, you can accept a resume. You don't have to have them sign an employment application form, but the best practice is to have your employees sign it so that you have an opportunity to get all those different clauses in the employment application form and ask those questions and get that information that you want to make an educated decision.
Okay. All right, this question came in advance. What specific legal notices is an employer required to give a new employee?
So thinking off top of my head, things that I could think of are sexual harassment policy. You need to provide that to new employees, and I think you have to do that within 3 months of when the employee starts, and you have to do that electronically, if I recall. There's a very specific way of doing it. You also have to provide notices to new employees regarding their rights under the paid sick leave law, under Connecticut's FMLA, including the FMLI process, the paid FMLA program. And also, believe it or not, under COBRA, we're used to thinking about COBRA and providing COBRA notices at the end of employment. There's actually under COBRA a notice requirement at the start of employment. Usually that, in my experience, that usually is taken care of by the insurer as part of the onboarding process, but it's just something that's out there that a lot of employers aren't aware of. Those are the ones that come to mind for me.
And I would use an orientation checklist. It's on the screen there. We have a bunch of different considerations, for the hiring process, and an employer should have a little orientation checklist of the various things that you review with all your applicants when you hire them, as you would on sort of day one of employment. You go through those things that Vincent just mentioned. You do the W-4, maybe you review the non-discrimination policy, the EEO policy, the big ones, the ones that you want to make very clear. We went over this on day one. And so I like orientation checklists. It just shows that, we covered that on the very first day of employment. And you update that as laws change instead of trying to remember, do I have to give the FMLA today or the policy, that kind of stuff. So.
Okay. This question was submitted in advance. How do you handle a situation when an individual comes in to fill out an application, you decide to have an interview, and you notice during the interview that they wrote down on the application that they left their last job due to being incarcerated? Is there any reason why you couldn't use that as your basis to not hire them?
Yeah, I mean, I think you can ask questions about that. I mean, if you're not comfortable because they're incarcerated, it doesn't necessarily, it would be the same kind of consideration that that I would give if somebody said, can I not hire somebody because they've been arrested, right? The incarceration alone doesn't necessarily mean that they're convicted. And so, somebody could be incarcerated, but then be found innocent. And so it's not necessarily a conviction. So you could ask about it, right? And then if you ask and the person says, I was incarcerated and then I was found innocent, and then you don't hire, you run into the same issue of, did you not hire because they were incarcerated but not convicted, or did you hire for a legitimate reason? So, if you interview someone and you notice that they're incarcerated and you continue the interview and you discover that there's another applicant who is better qualified and you hire that applicant, then no need to go down the route of asking about the incarceration. If they're the best applicant and you want to know a little bit more about that, I don't think you're barred from asking. You can certainly ask about that. And then you'll have to make a decision about whether or not that for you is a valid basis to deny employment, based on that, the facts and circumstances, the basis of the incarceration, whether there was a conviction. So.
Okay. And then I think the last question that came in advance was, can we Google candidates or look them up on LinkedIn before we reach out to them? What's the downside of that?
I think the downside to that is learning what I might call TMI, getting a little too much information, learning about some potential protected classes that the individual might be in that might influence your decision making. I think that's definitely one of the potential downfalls for it. But in terms of whether it's strictly illegal to do, I don't think so. It's just potentially dangerous. Again, you want to be careful of learning things that could influence you in making that decision the wrong way, in an illegal way.
Okay. Can you ask for the expected salary in a job application? Ask the applicant what they expect the salary to be or what they need their salary to be.
Yeah, you can ask it. That's an appropriate question. What you can't do is ask them what they've been paid, what they were paid in their prior employment.
Okay. Yeah, there's a difference between asking what do you want and what did you used to get, right?
Exactly.
Yeah.
Exactly
Okay.
right.
All right. So if a candidate said that he was on vacation, I'm going to leave that one I'm going to read that when you're talking later. I'm going to see if I can summarize that. Can you ask if they're physically able to do the job? Because most of our positions require physical work.
Yeah, so that's a tricky question. So if it's at the pre-offer stage, remember at the pre-offer stage, before you extend a conditional offer of employment, you cannot ask any question that is likely to elicit information about a disability. So the question, are you physically able to do this job, at the pre-offer stage could very well elicit information about a disability. No, I can't because X, or yes, even though I have X, I think I can do that, right? Very technically, what you could say, because it wouldn't require somebody to reveal whether or not they have a disability, and the question isn't likely to lead, is can you perform the essential physical duties of this job with or without an accommodation? Yes or no? And they say yes, right? You won't know if they can do it with an accommodation. You won't know if they can do it without an accommodation. So just saying, are you physically able to do it in and of itself, I don't think that's quite, for being very technical, probably doesn't go far enough. But you can ask that at the post offer. Once you make an offer of employment, you extend a conditional offer of employment.
Okay.
One thing, Diane, I don't mean to interrupt. I wanted to
Yeah.
just correct one thing I had mentioned in talking about clean slate. I misspoke when I was talking about the erasure periods. It's 7 years, like I had said, for the misdemeanors that may be subject to erasure. For those lower level felonies, it's 10 years. I'd said five, but it's 10. So I just wanted to correct that.
Okay. That's kind of a tricky. I mean, I don't know an employer who's going to know whether it was a Class E felony or a Class D felony and what the different years are for misdemeanor versus felony. But that's what the statute says.
Yeah, and that's when we're really hoping, the state had been in the process of actually doing that erasing process, not complete yet. It's taking longer than they had thought. And you hope that just over time that gets completed. And it's one more reason why it's probably a better idea to use a third-party consumer reporting agency to do those background checks.
Yeah.
So that, at the end of the day, it's on you as the employer, but I'd feel better having someone who does that for a living, who does that as part of their everyday business, trying to figure out what should and shouldn't be disclosed to me as an employer.
All right, so I'm going to go back to that question that I had you read more. Is there any reason, let's say you have an applicant who fails a drug test, but you really liked them. Is there any reason why you can't give them another chance 6 months later? Is there any, or let's say someone failed a drug test and it was just THC, and you decide, I actually don't care. I'd actually like to hire this person. What do you recommend there? In both those scenarios? One is you say, try again in 6 months. And the other scenario is, I'm going to hire you anyway.
I think it's okay to do. I would just caution that, you want to treat people consistently, right? You want to try to avoid potential disparate treatment type claims, treating folks different, trying not to open yourself up to potential discrimination claims. So, making exceptions for one begs the question of why you can't make exceptions for others. Doesn't mean you can't. It just increases that risk, the risk of that type of claim.
Okay. Can you ask an applicant if what happened at their other job? Can you say, were you terminated or were you asked to resign? And what were the circumstances?
Yeah, I think you can ask that question. Yeah, I think you can be very direct. Were you terminated from your employment involuntarily? You could get an entire story back, as to yes, and how unfair it was, and how it came on the heels of the person raising a complaint or going on FMLA leave, and then you can't then use that information, the fact that they took FMLA, or maybe they raised a covered complaint to deny employment at your place. So yes, I think it's a fair question. It's again one of these where you may get more information than you can actually use, in making an employment decision. But yeah, no, I think that's a fair question to ask.
If you don't believe them, can you just call the former employer and ask about this person?
Yeah, so you can do reference checks, right? I mean, again, this is where an employment application form I think is helpful, because you ask the employee to list, who are your prior supervisors, right? For the prior employment, and can we contact that person? And if they say yes, you can contact them, right? Sometimes they're going to say no because they're still employed there. They don't want you to contact, in which case you should not, right? You don't want to invade privacy either. So, the employment application form is your opportunity to get consent to contact a prior employer for a reference check. So.
Okay. This question is, can you list the following: successful results on a criminal and sexual abuse background screening is a prerequisite, I think this is what they're saying, on a role description, and have your offer letter be subject to getting a clean report on those. I think the answer to that is yes. That's kind of a
that's exactly where you want to do it. Is this offer is contingent upon you passing a background check, you passing, a background check. I mean, a drug test, a background check, I-9, authorization to work in the U.S. That sort of. Those are what we mean by the contingencies.
Mm-hmm. Okay. Got a lot of. It's interesting. We got a lot of pay range questions, and we were answering those questions a couple years ago all the time. Vincent, I don't know if you've got that salary the statute in front of you, but the question was, what's the definition of a salary range?
So as used in the statute, it can include reference to any applicable pay scale, previously determined range of wages for the position, the actual range of wages for current employees holding comparable positions, or again, I'm pulling this from the statute I do happen to have in front of me, or the amount budgeted by the employer for the position. So one of those four things, using reference to one of those four things counts as what the wage range is.
It's pretty frustrating. Do you
Yes,
agree?
it
Like
is. It is very frustrating. On the
that's
one
why I
hand, like
asked
the
you if you
easiest.
had the statute in front of you, because it's there in the statute, but it's very unhelpful.
And it's kind of a lot of gobbledygook, right?
Yeah.
It's a lot of employers just wind up, even though they don't really want to, they wind up, a lot of them, just to be safe, wind up using the third out of the four, which I think is the clearest, which is the actual range of wages for current employees that actually hold that position.
Mm-hmm. All right. This question is the Connecticut wage notice at time of hire only applicable to non-exempt roles, or is it for all hires?
I think it's for all hires. I'm not aware.
I think it's all hires too. I'm not aware. Yeah, I'm not aware that it's limited to non-exempt.
Okay. What about disclosing commissions and bonus structures? Do you have to disclose that?
So the definition of wages in the statute is really broad, and it includes compensation, whether the amount is determined on a time, task, piece, commission, or other basis of calculation. So yes, you do have to include that. What you don't have to include, though, is something like a purely discretionary bonus, that the employer has pure discretion whether and in what amount to award. But if commission or some type of incentive comp is part of it, then I'd say yes.
Okay. What is your position on welcome periods and probationary periods?
Yeah, I'm okay with them. I usually call them an introductory period. I wouldn't, not crazy about the term probationary. I mean, as long as they have a purpose, you do an introductory period because at the end of the introductory period, you want to do a performance review, an initial assessment of employment. You do an introductory period because you don't allow the employee to use paid time off during that introductory period, subject to the sick leave requirements and all that stuff, right? And you have it worded properly in the policy, what the introductory period means and what it doesn't mean. It's employment at will during the introductory period. It's employment at will after the introductory period. Your employment may be terminated, at any time during the first, 60, 90 days, and it may be terminated at will after the introductory period is completed. So, and you're not guaranteed, 90 days or an entire introductory period. So if there's a purpose for it, like I said, usually it's reviews, like we're going to do an initial assessment, or, you're not going to be able to use accrued PTO within that period, then I think it makes sense. So you just have to be careful about how you word it.
Okay. Is it legal to randomly test an employee for marijuana?
Not unless federal law allows you to, like, for example, in the context of the DOT context. But aside from that, generally in Connecticut, you can't just randomly test.
Yeah. You can get a position classified as a safety sensitive position, through the Connecticut Department of Labor. There's a process for that. You can actually do it online. You go to the Connecticut DOL website and you apply and you say, look, I think this position, they drive a forklift, whatever it might be, is a safety sensitive type position. I'd like to have it designated as such. You send it to the DOL will review it. And if they designate that job classification as safety sensitive, then you can do random testing. And they have a list of jobs on their website that they have previously designated as safety sensitive, but you can't rely on that list. You need to get specific designation for you, your company, your employer, in order to do random testing.
And
There's some other exceptions too, but I think those are the big ones.
Well, the other one, which I don't know that we mentioned, though, is if you have reasonable suspicion that the employee is under the influence at that time. And, reasonable suspicion, is a loaded term. It's based on a combination of factors, including things like appearance, behavior, speech, smell, kind of those type of articulable factors. That's the other situation in which you can test during employment.
Yeah, and so that can take us into our next question. And I'll just point out that there's a difference between testing someone and firing someone, right? So this question is, can you let someone go for coming to work under the influence of marijuana if they have a drug card? That's one. That's one thing to consider. If the person smells like marijuana, can we send them home or fire them? I feel like there's there's a couple things going on there in that question.
Yeah, I would say that the palliative use of marijuana law does not permit or require does not permit or explicitly require employers to permit employees to come to work under the influence of marijuana. So you can't discriminate against someone solely because they're a qualifying patient. That doesn't mean you have to tolerate them being at work under the influence. But that's where, that's the elephant in the room, right? Someone might present with reasonable, with some symptoms that you think give you some, that reasonable suspicion to test them. And so what? They test positive for marijuana. Of course they will, because they're a qualifying patient. So maybe in that case, the test doesn't really get you what you need. That doesn't mean they were under the influence right then and there. But yes, you can still conclude, it is still legal if you conclude that based on specific articulable symptoms that the employee has presented with at work, that you've reasonably concluded that they were under the influence, you could, terminate someone for making that, as long as that's a good faith basis to make that conclusion. I think it's a high bar. It's tough to prove. So you have to tread very, very carefully there. In the example that you use, simply smelling like marijuana, I'm not sure that by itself is enough for you to conclude that they were under the influence at that time, in that moment. I would look for more. Is their speech, is their behavior, is their dexterity, their coordination impaired? Are there, are they acting in a disruptive way? What other kind of, what other things are happening that can support a conclusion that person's under the influence right then and there?
But you can probably send them home. You could just based on the fact that, they smell like marijuana, and you have customers. Yeah, you have customers that come in, they're facing with other employees, and it's a strong odor, any odor that is just disruptive, or it's just not necessarily conclude that they're under the influence. But, that's your first strike against the person, and then they come in again and again, and little by little, you begin to build a case that, the next time they seem like they had other signs that they were under the influence. So probably a good first step.
What would the risk be to the employer if the employer said, let's say the employee really smelled like marijuana? It's true, you don't know if they actually are under the influence, or if they were just in a car where someone else was smoking marijuana. If you let the person go because they smelled like marijuana, what will that violate? What law will the employer be breaking?
Well, I guess you let them go because they smell like marijuana.
You suspect them of using drugs. You might be right, you might be wrong, but they're an at-will employee. So what's the risk there?
I mean, it's lawful in Connecticut, right? I mean, you're probably right from a pure technical standpoint. Diane, would that raise some kind of wrongful termination claim? I mean, you need to make it clear in your policy, I guess, that you prohibit. I mean, you want to make it clear you prohibit anything that indicates that they're under the influence at work, including smell. Like, right? I mean, are you going to, would you? So, I think you're right. There's not a clear law that you'd be violating as long as it's in your policy that you prohibit that, and you've got a reasonable basis to conclude that.
You might be fine under the, in the context of recreational marijuana, but, you could think of facts and circumstances that might make it a little bit more problematic under the medical marijuana statutes. An employer, you could imagine an employee saying, yeah, this is my jacket. It's at my house. I have a card I use at my house at night. That's why my jacket smells like that.
Mm-hmm.
Of course.
Mm-hmm.
So I think that when you bring the medical piece into it, makes it a little bit trickier.
Yeah. All right. Well, that was interesting. I did not anticipate getting so many. That was like heavy on salary disclosure and heavy on drug testing and background checks. But so you can see from this slide, this is the checklist that Vincent and Nick prepared, things that you can refer to as you're conducting the hiring process, things to keep in mind. If you look through this list and you don't know what they're referring to, you can reach out to Vincent and Nick at Carmody Torrance Sandak Hennessey, as always. And that is it for today. So thank you, everyone, for joining us. And we will see you in probably a couple of months for our next one. Thanks, Vincent and Nick, as always, and I'll see you next time.
Great.
Thanks, Diane. Thanks, everyone.
Everybody.